Hi guys, it's Kathy, and I just thought that I would talk to you on video this time because it's been a while. I am embedding my voice in a PowerPoint that I have that will be posted as well, and that's more on the juvenile court that we're talking about this week and the juvenile justice. But I wanted to talk to you about some cases that are really important in the juvenile justice system because you're going to learn from the PowerPoint that we didn't treat children so well in the past. We had horrible things. We let them work in mines and the most dangerous places. They took up a third of our workforce at one time that were in factories. They worked 7 days a week, and we had to pass special laws just so they could have off a half of day, and that was on a Saturday. So these kids were as young as 8, working in mines. It's just a pretty rough time of our United States history. But once we got juvenile courts, which your PowerPoint talks about how we got to there, we still had a long way to go. We really didn't have the same rights in place. So there are some really important legal decisions that happened. And I won't go on for more than 15 or so minutes. I try to keep my videos down there. That's why some is in PowerPoint and some is here. So you get a variety. But let me tell you about some of the constitutional rights of children, because it's really weird. There were some really important rights that were passed in the 1960s about due process, and one of them, you probably heard of it, Gideon versus Wainwright. We hear about it, there are movies about it, and that's where the court ruled that having a lawyer is necessary for a fair trial, and that it's promised to us by the Sixth Amendment of the Constitution. So the U.S. Constitution says in all criminal prosecutions, the accused shall enjoy the right to the assistance of counsel, counsel being a legal word for lawyer. So it took till 1963 for Gideon versus Wainwright, the Supreme Court, to say that any defendant that's charged with any crime has the right to an attorney. And if that defendant cannot pay for a lawyer of their own, then the state must assign them a free lawyer. That was huge to us. And that's how a lot of missteps and missteps in the miscarriage of justice happened before Gideon versus Wainwright. The other case I'm pretty sure you've heard about too, and that talks about the 14th Amendment, where, well, we also had a couple others, and we also have the right against self-incrimination. So Miranda versus Arizona in 1966. Mr. Miranda got in a fight, and when a person is being asked whether they committed a crime, they don't have to answer. That's what that case stands for, Miranda versus Arizona, which we now just say, how about your Miranda rights? And we all know, layperson, legal person, everybody on TV knows Miranda rights. Well, it comes from the case of Miranda versus Arizona, and it just says that you can't get in trouble for not answering when police ask you questions. This is called the right against self-incrimination, the right not to say anything that proves you committed a crime. You have the right to defend yourself by just being silent. Now, if you lie, you open yourself up for a lot of other things. That's not a good idea. Remaining silent is always the better idea, which is why I always say when asked questions by police, even if you haven't done the robbery down the street and they're asking you, if they have it in your head that you did it, believe me, every answer you have is going to be perceived through the glasses, the lens of your guilt, even though you're not. So it is better to just say, you know, I'd love to answer your questions, but I want a lawyer, and say the word lawyer, which then means they have to stop the questioning and not restart the question until you get a lawyer. If you just say, I don't want to answer questions now, but don't invoke your right to a lawyer, which we just learned in Gideon versus Wainwright is correct, although that was for when you're already charged, they could keep asking questions later. They just take a break because you didn't want to answer them now, but you might have just been thirsty or something and then want to answer after that. So you want to always say, and I'd like a lawyer, and then they need to stop and they can't start again. The 14th Amendment says no state can take away a person's life, liberty, or property without due process of law, nor deny to any person the equal protection of the law. Due process is so important. It's a phrase that you hear a lot, but you're really not sure what that means. Due process means I get all the rights that are afforded to me before you can take me away, find me guilty, sentence me. I get all those due process of law, the things that protect me and cloak me with the veil of innocence, because I am considered innocent until you prove beyond a reasonable doubt to an independent court that I'm guilty. So those are really important rights. But we had, by the 1960s, the things called juvenile courts, and you'll learn those in the PowerPoint. So there was this guy, and so you wonder, so what happened? Well, interestingly enough, we would have children that were deemed delinquent because we didn't call them guilty because they were in special courts, juvenile courts. So the judge could make the child a ward of the court once they're found delinquent. Well, we weren't quite sure what to do with those constitutional rights. Do children get the same rights as adults? Well, it seems clear to us today that of course they should. But in the 1960s, that wasn't so clear to us. And on June 8th, 1964, a police officer arrested Gerald Galt. He was a 15-year-old kid. And the sheriff didn't tell his parents, his mom, that he had been arrested. He had been arrested after a neighbor named Ora Cook complained about receiving an obscene phone call. At the time, Galt was already on probation. He had been put on probation for 6 months starting in 1964 February for being with another boy who stole a woman's wallet. Galt's mother came home, realized he was missing, eventually found him at the county children's detention home, but she wasn't allowed to take him home at that time. So without being charged with a crime, he had been put in juvenile hall. He always has said all the way through to 2007 when he was interviewed that once he heard what his friend Ronald Lewis did, and Ronald Lewis is the guy that he says actually made the phone call, that Galt kicked him out of his house, that they were over at his house. And they obviously used the phone from his house. The Sixth Amendment to the Constitution. Okay, so I'm sorry. So Judge McGee was usually working in Superior Court then, but actually he happened to be working in juvenile court that day and had a hearing with poor Mr. Galt and decided he would think about what to do and sent Galt back to jail. Like, he can go to juvie hall now. So he's going to stay there a few more days. At the second hearing, Judge McGee ruled that Galt was a delinquent child, which meant that Mr. Galt, 15 years old, broke the law and ordered him to be sent to the state industrial school. You'll also hear about industrial schools and houses of refuge and reform schools and all the other things that we did to children, and sent him to the state industrial school until he was 21, unless the court decided to let him out before that. Wow, he was 15. He was being accused of an obscene phone call, and if he were 18 and an adult, the Arizona laws would have had a maximum penalty of 2 months in prison and a fine from $5 to $50. So 2 months is the maximum that I as an adult could get punished for. But because Jerry Galt was a juvenile and 15, committing the same thing, an obscene phone call, which frankly he denies, but even if he were found involved, he was going to jail for 6 years. That's kind of crazy, right? So Galt's accuser, Miss Cook, never showed up at any of his hearings. Judge McGee said she didn't have to be present. He never told Galt's parents that they could bring a lawyer to the hearings or that they could call witnesses on their own behalf, because the judge didn't believe that he had to do that for Jerry Galt, because Jerry Galt was 15. What do we care? So his mom was smart enough to say, wait a minute, my son just went away for 6 years for an obscene phone call that an adult goes away for 60 days. This is kind of crazy. So they asked an appeal for that. So they appealed it to the Arizona Supreme Court, and the Arizona Supreme Court ruled against the Galts and said that neither the juvenile code nor Gerald's conviction violated due process, because that was their accusation, that he wasn't given the same due process that an adult would be given, that he didn't have the right to a lawyer, that he didn't have the right to a fair trial, um, that he was, sorry, my screen went dark. So anyway, he appealed then to the United States Supreme Court because the ACLU, the American Civil Liberties Union, some of you are assigned to that, right? I think in your groups for that that organization. Anyway, they got involved and they went before the Supreme Court and they had the following legal arguments. The specific question: were Jerry Galt's due process rights violated when he was convicted and sent to juvenile prison? And if they were, what should happen to him? The next question, the general question, was the Arizona Juvenile Code unconstitutional because it didn't give juveniles the same due process rights in the 14th Amendment of the Constitution that are awarded to adults? And the biggest question of all is, did juveniles even have the same due process rights as adults? Did the 14th Amendment even apply to juvenile court processes at all, because they're not called criminal courts, they're called juvenile courts? May 15, 1967, because remember, wheels of justice turn mighty slowly. The Supreme Court voted 8-1 in favor of the Galts, and they ruled that Gerald's due process rights were violated. Justice Abe Fortas wrote the majority opinion, meaning for the 8 justices that were the majority, and said the major difference between Gerald's case and a normal adult criminal case is that protections available to adults were discarded in Gerald's case. The summary procedure, as well as the long commitment or imprisonment, was possible because Gerald was 15 years of age instead of over 18. Justice Fortas pointed out that if he were over 18 and tried in the adult court, he would have many different rights, including the following: the right to be told what he was charged with and when his hearings would be, with enough time to prepare those. And that comes from our 14th Amendment, the due process. He would have the right to an attorney, free if the family can't afford one, guaranteed by the 6th Amendment and reinforced by Gideon versus Wainwright. The right to call witnesses and show evidence that he was not guilty at his trial. That is guaranteed by our 14th Amendment in due process. The right not to answer the judge's questions about whether he was guilty. That's guaranteed by the 5th Amendment and Miranda versus Arizona. But because he was 15, he got none of those rights. So Judge Fortas wrote that without the due process rights, a person cannot get a fair trial no matter what age they are. That the 14th Amendment says no state can take away any person's life, liberty, or property without due process of law, nor deny any person the equal protection of the law. Since juvenile courts could take away children's freedom by sending them to juvenile prison, they needed to give juvenile defendants full due process rights. They also need to give them equal protection of the law, which means just the same protections an adult at risk of going to jail. So they threw out his conviction and ordered him to be set free. He had spent 3 years at the industrial school. 2 years, 10 months longer than any adult would have spent. And what that did to him, who knows? You'll learn that those industrial schools are just like prisons. We said they were just supposed to be more nurturing for juveniles and to take care of the people after we had them working all their life, and then we told them juveniles shouldn't be in factories and mines, and we shouldn't have them work for room and board anymore, that we can't do that. They then became homeless. They were very poor, they were destitute, and so they committed a lot of delinquent acts. So throughout our history, we have a lot of problems with our juvenile justice system and delinquency of juveniles, besides the fact that hormonally they're just going to commit more violent acts and that kind of thing than older people, just because the amount of testosterone running around for some of them. So anyway, that is the poor story of In re Galt, and we call it In re Galt instead of something like Gideon versus Wainwright or State of Maryland versus Kathy Hill. We say In re Galt in juvenile cases because they're supposed to be confidential. You're not supposed to tell all about their case, and so you wouldn't say Jerry Galt. You wouldn't say his whole name. So that's how many of our Supreme Court juvenile cases are. So now you know the story of some of our really important cases that impact juvenile justice.